Hi, everybody. My name is Genevieve Fikes. I work with Gary Berger at Berger Law. As you can see, he's not here today. He's with his family, but we're still going to do Ask a Lawyer. I am, in fact, a lawyer. I have been for about 10 years now. And I have to say, Gary has been the best boss so far out of everyone I've worked for. And I'm here to do this Facebook Live video. And I hope I still have a job afterwards. So go easy on me. This is my first one, but I'm happy to answer any questions that you all have. So we've gotten some this week. Let me see what we have so far. All right. One of the questions that we got was, what type of records, documentation, etc. are most important to have when you're trying a personal injury case? What can the plaintiff provide you that's the most helpful as a lawyer? So really, photos are important. If you have a car accident, photos of the car, of the scene, but also photos of injuries. Photos speak, when you see a photo of scarring or burning or casts and all of that information, it just really speaks to the extent of somebody's injury, and those can be very helpful. Sometimes the photos don't help. We've had cases where there's a car accident and our client barely has any damage to their car, but they're actually very injured. Photos of property damage don't always reflect the severity of somebody's injuries. So in cases like that, we don't always use those photos. Other times we have cases where a person's car is completely totaled and they aren't as injured, but when you look at the photo, you think there's no way that that person wasn't hurt. Another thing that we look at are cell phone logs. These days, almost everyone has a smartphone. A lot of people text. A lot of people are on their phones when driving. And we can get those call logs to see if the person in the other car was texting or driving at the time that they had an accident, and that can help your case. Let's see what else along those lines. Really, medical bills, those are the other documents that we use all the time. Of course, in the case, that's how really the jury can determine the value of your damages. And let's see here, I have another question. Here's one from Brennan. It says, when do you know you have a good case? I'm sure you get random calls all the time about someone tripping at Lowe's and wanting a settlement. Well, if you trip at Lowe's, we would actually be happy to look into that case for you. Not every slip and fall case is good, but a lot of them are. And so this is what we look at. First of all, who did something wrong? What was the dangerous condition that you fell on, or sometimes that fell on you? And how long was that dangerous condition there? Some examples of some good slip and fall cases we have are where people actually slipped and fell in a bathroom that had just been cleaned by the employees and they didn't put any sign up. We're able to figure out what their schedule was. We know that an employee of the company did it and they're at fault. And those cases are usually pretty successful. Now, if you're at the grocery store and slip on a grape that you dropped yourself, probably not going to be able to help you out on that one. And then the other part of a case is not just who's at fault, it's also how injured are you. No matter what, we get pushback from defendants on slip and fall cases. A lot of times they're saying there's comparative fault. You have to look where you're going. And they're in dispute. The other part of a case is how injured are you. You may break an arm or you may just have some bumps and bruises. But unless you get significant medical treatment, there's probably not much that we can do to add value to your case. So we look at the type of injuries and the type of the dangerous condition, who is at fault, and then if you can get a hold of us or someone soon enough, we can try to get that video surveillance that shows what happened, because we all know there's videos everywhere. Unfortunately, something that we've seen, of course, which isn't surprising, is if the video hurts us, the store is happy to give it to you. But if the video would help our case, then it mysteriously disappears. So that's something we deal with a lot. But, we're happy to look into any case, because stores do have an obligation to be safe. It's not just slip and falls. A Lowe's example could be if you are reaching up and there's stacks of wood that are unstable and they tumble on top of you, you might have a case there. And for those of you who are just joining, I am here for Gary today. My name is Genevieve Fikes. I'm an attorney of 10 years, and I've been working with Gary for a couple years now, and really love what I do. So let's move on to another question. Thanks, Adam. I know Adam said, "Hey, Gary, you look different." I tried to channel my inner Gary today by putting on the seersucker jacket. It's been in my closet for the past 10 years collecting dust, and very few people can pull it off. Gary's one of them, but I figured that he'd approve. So let's see. We have from Davey, how often do personal injury cases go to court rather than settle? This is the perfect lawyer answer. It depends. And it also depends on what you mean by go to court. Not a whole lot of cases go to trial in front of a jury, though Gary and I try a few cases every year on ones that don't settle. But the vast majority will settle at some point, although sometimes we have to file a lawsuit. When a case first starts out, it's just a claim, and we gather the information, we send it to the adjuster, we try to negotiate a settlement, and a lot of those cases do settle. But it also depends a lot on our client, too, and their perspective. Not every, here's another example. A case can settle as soon as an offer is made, but that first offer might be really low. And we think that if you give it more time, then it'll be worth your while. Other times, you could think that it will spend a whole nother year working on the case just to get another $2,000, and it helps to settle. But as far as average timing goes, one of the biggest things that impacts that is the nature and extent of someone's injuries and if they're still treating. So a lot of times when someone's really hurt, they might have physical therapy first and treat conservatively. They might go to a chiropractor for a few months and not get better, and then need a surgery. And then after surgery, there's recovery time and more physical therapy. So the clock doesn't really start ticking until you've finished your treatment, because the whole point of these cases is to get compensated for your medical bills, for your injuries, for your lost wages, for any future treatment that you might have. And you just don't know that until you're done treating. So I would say that on average, after you've finished treating, if you don't have to file a lawsuit, your case should settle in half a year, a little more, a little less. If you have to file a lawsuit, it's probably going to add at least another year. At this point, maybe even longer, because there aren't any jury trials going. So I'd talk a little bit about that too. A lot of people are wondering, how has this pandemic and coronavirus impacted the court system and our cases and all of that? And, as Gary said, we are still working hard, still working remotely. Every court does things a little bit differently. Just last week, I was in court in person in Decatur, Illinois, and also in Greenville, Bond County, Illinois. So it's been my experience that in Illinois and some of these smaller towns, they're still operating as usual. And then for other places like the city of St. Louis or St. Louis County, a lot of stuff is done remotely through Zoom, but we're still able to move the cases along and prepare as if we're going to trial. Just recently, I had a case where we did a pretrial, and basically a pretrial is getting everything together before you have an actual trial, and the judge will rule on things. You have to get your witness list and your evidence and exhibits and motions to get evidence in or to keep it out. And I was fighting an attorney who represents Allstate, and Allstate never settles. They just don't, and they always have these very lowball offers. And, we kind of knew going into this pretrial that our trial that was scheduled for the Monday after 4th of July would be continued. But they had the hearing anyway, and Burger Law got all of our stuff together, sent it to the judge as if we were going to trial, and the other side did absolutely nothing, just because they knew the trial wouldn't happen. The judge was not happy about that, and the other side actually doubled their offer. So it had been a very bad offer before. Now it's just a mediocrely bad offer, but it is better than it was before. So we are treating things as if they could go to trial at any time. We're still having settlements, and we're still getting new cases and progressing those along. I'll see what other questions that might come in. All right, what do we have from Maya? Maya asks, if a plaintiff in an injury case is not organized and does not or did not retain documents for medical treatment and other important stuff, do they have any chance of winning the case? Do you help them obtain, and what records can you get? Is there anything that they can provide instead as evidence? So really, that's the attorney's job. Part of what we do as a team with our paralegals as well is we order all the medical records. We get all the medical bills. We put it together. We will summarize your medical treatment that you had with the injuries and describe why the other person's at fault, and submit that with the police report and the photos, if it is a car accident case, and handle all that for you. We know how to order the records. We can get them relatively quickly. It depends on the provider, but we really don't need a whole lot from our clients, just to help us out, cooperate, and be patient throughout the process. Again, some exceptions would be if you have good photos of your injuries or of the scene or of a car, if a car is involved, of the dangerous condition. Going back to if there's a slip and fall at Lowe's and you have your cell phone on you, take a picture of it. So often the other side or the adjuster will try to claim we can't even prove that anything was there. So if you can get witness statements, take photos, that always helps. But don't worry about getting everything yourself. Give us a call and we can take care of the hard stuff for you and take that off your plate. We can get employment records, any of that kind of stuff. All right. Again, if some of you guys are just joining, we decided to switch it up a little bit this week. People were getting tired of listening to Gary talk about his beehive all the time, though we are interested to get some of that honey. But I am here to answer some questions. I've been working with Gary for a few years and practicing as a lawyer for 10. really love what I do. Here is another question that we have from Rodney McBride. He says, how important are support staff like paralegals in the legal field? Have you ever had a paralegal who is super awesome? I really haven't. No, I'm just kidding. Rodney is my paralegal, and he is absolutely amazing. We work as a team. We sort of have different things that we do to contribute to a case, but our paralegals do a lot. They have the hookup to get the medical records. They know where to get them. They know how to handle them. They talk to our clients a lot and give them the case updates. I wouldn't know what to do without my paralegal, Rodney, and I can say the same for really everyone else who works at our firm. Paralegals tend to have different roles depending on what law firm it is or what type of law, but ours are very actively involved, and they're another resource really for our clients to reach out to in the event that they want a case update or anything of that nature. Also, our paralegals will get, follow up and see, are you still treating? Do you have any photos? They reduce medical liens, so sometimes they do this stuff. I'm so glad that I don't have to do it, and I really appreciate that I have Rodney here. But at the end of a case, we try to reduce whatever medical bills there are, and that can be a challenge. Sorry, I have a cat that's trying to make an appearance on the video. This is Bentley, but we're gonna take him off the screen for now. He's not really very helpful, unlike my paralegals. But yes, Rodney is an amazing paralegal, and we definitely need them to help us out. So here's a question from Adam. He says, if an insurance company sends you a lowball settlement check on your claim, can you cash that check but then sue for more later? Or do you have to push back and not accept any money at all from day one? So they may give you money on your property damage if it's a car accident, and that's okay to take that, but you want to make sure that you don't sign anything like a release that takes away your right to get more money later. And a lot of times these insurance companies aren't going to just give you a check unless you sign something saying that you agree not to sue them in the future. And the question is, if an insurance company sends you a lowball settlement check, any first offer that they give you is going to be lowball. And so we would recommend absolutely that, you don't cash that check if you want to pursue something and, get a larger amount later. Something, not everyone is injured all the time or severely injured, but something to remember is that sometimes you don't know the extent of your injuries right when an accident happens. So you might be having a lot of adrenaline and feel all right, but then, a couple days go by, the swelling increases, and you realize you're in worse shape than you thought you were. And so you really don't want to accept any sort of settlement until you know whether or not you're going to need more medical treatment or if you have other issues in the future, because once you sign a release, you cannot come back later. So that's definitely something to keep in mind. Let's see what other questions we have here. Here's one that says, how tough is the bar exam? It's got a stigma being the biggest deal ever. The bar exam is hard, and it's supposed to be hard. It's a lot of information. I and our whole firm, we really specialize in personal injury law and do some employment and wage and hour, but the bar exam tests everything. So family law, evidence, criminal law, trust and estates, property, constitutional law, secured transactions, corporations. I don't even remember the rest of them because thank God I don't have to take it again after 10 years. But the bar exam is not fun. There's a multiple choice part that's purposefully tricky, tricky on purpose, and then an essay part. And you have to study a lot for it, but it's good. I know a little bit about everything, I feel like, even though I don't specialize. And you at least know when you need to know something or get an answer from a specialist. We get this question a lot. This is from Michael about the overtime lawsuit settlement for the Department of Corrections. We are still waiting for the Missouri Supreme Court. Gary argued the case and did a great job with the Missouri Supreme Court in April. And the Supreme Court can hand down a decision this month, or it could be a year. Hopefully it will not be that long. But it has been quite the process. So for those of you who maybe aren't familiar, we had a big wage and hour class action case, and Gary won at the jury trial level, and that was at $117 million verdict. And then the other side appealed it to the Court of Appeals. We won that too. And now it's at the Missouri Supreme Court, and we're just waiting to see what they'll say. But we are just as excited to find out what happens as well, and we'll make sure that that information gets posted everywhere so that everybody knows, and it'll be on our website as well. Let's see what else, what other questions some people have. So some people are hesitant to file a case, and they feel bad suing somebody and wonder if the person that they're suing has to pay for a lawyer. They do not. So if you have a car accident claim, a medical malpractice claim, a homeowner's claim, and it's up against a defendant, that person, dog bite too, that person's insurance company provides the lawyer for free. And so, this is why people have insurance, so that if something happens, they don't need to worry about it, and someone will defend it for them. I joke around that one of my goals in life is to have more paid out in claims in car insurance than I pay in premiums, which I'm on my way to based on how I drive. So, if you're in an accident and you're injured and it's not your fault, there's no reason why you should be the one that has to bear the brunt of that when you're already in pain. You're maybe missing time from work. Your car might be totaled and you have no way to get around. That's why we work. That's why we're here, to help you get paid. And really, the money that's coming is from the insurance company. And so that kind of goes along with the question that we got that said, that was about collecting money. It says, after winning a case for a car crash, how do you go about collecting the money owed from the other driver? If they have insurance, then the insurance company will pay it to us. We take care of that for you. And it's not a problem. If there is not any insurance, then it's a different story. Typically, our firm doesn't go after people individually or their own assets or their house or anything like that. We're usually just looking at, the amount of the insurance coverage and whether that's sufficient to cover someone's claim. And that, another thing that goes with that about if there's enough insurance to file a claim, or should you file a claim at all on your own insurance. I think this subject's come up before, but a lot of people have questions about underinsured coverage. There's a lot of people on the streets who have minimum car insurance coverage. So they're driving around, $25,000 is all that's available. You're in a head-on collision, lose your job, $100,000 in medical bills. What can you do? Well, you can take that $25,000 from the other side and then file a claim on your own insurance. And a lot of people ask, won't that make my rates go up? There's actually, Missouri has statutory regulations that make it illegal for insurance companies to raise your rates because of an accident that you are not at fault for. And even logically, I don't always trust insurance companies to do that. I had my car carjacked one time and totaled, and my rates were raised, and that was not my fault. But when it comes to an underinsured claim, usually the benefit that you get from filing it far outweighs not filing it. So if you have additional coverage on your own policy for $50,000 and you can collect that for your injury claim, that's going to be way more than anything you would ever pay in premiums. And then again, it's not legal for the insurance companies to hold that against you. And that's the same for an uninsured claim if somebody hits you without insurance, or MedPay, which is another type of coverage that you get that you can choose if you want, that will pay some of your medical bills for you. Let's see if we have any other questions. Here's one that says, I'm thinking about getting a dash cam to protect myself in a case if I'm ever in a car accident. How often is dash cam footage used in a car crash case, and can it be used against me? I actually have had some dash cam cases before, and it was incredibly helpful. It was sort of a T-bone situation, and the whole thing was caught on video. I mean, literally, we just basically had to send the video to the other side and say, look, your guy was at fault. And in that case, it was really important because when the police come, they don't pick sides. They don't talk to, they don't make a determination of who's at fault usually because they didn't witness the accident themselves. It's basically hearsay. What they do is they just take the statements from both people. If one of the people driving the car admits that they didn't stop or weren't paying attention, then the police report might note that and say it's a contributing circumstance. But sometimes you're in these situations where it's your word against somebody else's. And if you have dash cam footage, it can help you. Also, I think that you can get dash cams online pretty cheap these days. But then the second part of that is, can it be used against me if I end up being at fault? Technically, if you disclose that you have it, then it could be used against you. It's not a question that comes up very often before lawsuits filed. I don't typically have any insurance adjuster asking me about that kind of thing, but it does come up when an actual lawsuit is filed. There's a standard question that says, can you produce any videos you have, any photos? And it's sort of the same thing as with these companies I talked about, where a lot of times if the video helps them, you get it, and if it hurts you, you don't. But I think dash cams are a good thing. And, frankly, if you're at fault for an accident, you're at fault for the accident. And your insurance company should defend you. The person who was hit deserves compensation. Nothing that terrible will happen to you if you have, basically, I think that dash cams are helpful and that they should be used. And if it hurts you, then you probably shouldn't be having a case for yourself, but maybe you can help someone else out. I've always said if I cause an accident, I'm just going to admit it. I'm going to say it was all me. I am a, defense attorney's nightmare as far as a witness would be, because I just want people to get paid from the insurance company. So that's kind of my answer to that question. Here's one that says, am I responsible for the sidewalk in the front of my house between my fence and the street? I always put down ice melt when it's bad out, but can I be sued if someone slips on that sidewalk and gets hurt? What about the alley behind my house? Same thing. So this is tricky. Sometimes it can depend a little bit on what county you're in, if it's St. Louis County or the city, but a lot of times there's joint responsibility for it. For example, if you look at a sidewalk and there's tree roots and it's all unlevel and someone falls, I mean, there's not really an expectation that you take care of that. But as far as slip and falls, I mean, you can get sued whether it's your responsibility or not. And we see that happen. Someone slips and falls on a sidewalk and they might sue the homeowner, the city, the state, all of it. So I think it's good to keep that clear if you can, just to protect yourself. All right, so if anyone has just joined, again, my name's Genevieve Fikes, and I'm an attorney. Been practicing for a long time and have been working with Gary. It's my first Facebook Live video, and I, again, hope I don't get fired afterwards. But it's nice to meet you all and reach out to everybody. Let's see. I'm looking at some other questions that we're getting. Can you tell when an insurance adjuster gives in and starts sweating? Is this an over-the-phone thing? That's a good question. Yeah, I feel like you kind of can tell. They try not to act nervous about it, but after you've been doing this long enough, you kind of have that BS radar where like they are not, they're saying they don't have any more money, but that they do, or they're going to have to go up the chain just to someone higher level than them who has more authority. We do typically communicate a lot with the adjusters over the phone. We'll send them the written packet with the settlement demand and the records and communicate via email, but a lot of times those phone calls are helpful in a case. And just like lawyers, adjusters are all different. I've met some who are very friendly, cooperative, relatively transparent. And then I've seen the complete opposite. Maybe ones you can't even get a hold of at all. Ones who will deny objective evidence of an injury. One of my favorite stupid things I hear is that some of these insurance companies hire nurses allegedly to do their own review of the medical records and come up with their opinion of whether or not someone was hurt. And, it's like, you didn't see the patient. You didn't, physically examine the client. You aren't the orthopedic surgeon who determined that this person has this injury. You didn't interpret the MRIs. So, they can try their tactics, but, ultimately, we have the most leverage because we can file a lawsuit. An adjuster's kind of biggest nightmare is us filing a lawsuit. And that's the only thing that makes them offer more money. Because without a lawsuit and the risk that a jury could give you more than what they're offering, there's nothing that can make them pay you. And so we get that a lot. People are like, why isn't my case settling? And it's like, well, they're offering, $10,000. You can take that, or we're just going to have to keep going along and go through the process. So something that has been effective for me lately, and hopefully there's no insurance adjusters listening to me right now, is to draft a lawsuit, send it to the adjuster with your bottom line offer and say, if you don't pay this by Friday, we are filing this lawsuit. And it's legitimate. It's really when you get that to that point in negotiations and we are speaking with our client and saying, look, we don't think this offer is good enough. So we think you're better off if we file a lawsuit. But before we do that, what is the lowest amount that you'd be happy with that we think would be reasonable compensation? And we will send the lawsuit, draft it up. And more often than not, I have gotten them to pay what we're asking for, which is a fair settlement. And then if they don't do it, file the lawsuit. But that's when I've had some adjusters get nervous, is, the threat of a lawsuit. You could get a jury and they could give you 5 times more what they're offering. Let's see what other questions we have. Going through. Rodney says, if I'm an unsafe gun owner and accidentally shoot, let's say, protesters in the street who are not on my property, is my homeowner's insurance liable? I feel like a similar situation almost occurred recently. And I would have to check that out. So we talk a lot about car accidents, but you can have claims on people's homeowners insurance too. But we really have to see the policy. So that's something that we would do if someone thinks they might have a claim. Homeowners insurance can cover something like getting hit by a golf ball. I've seen that before. But they might exclude flooding if it's from, rain versus a pipe breaking. It's just depends on the policy. And just like anything else, the insurance companies go out of their way not to pay. But that's an interesting question. And it would be interesting to see if a company would cover that. Though I have a feeling they might not. But, it's worth a try. Thank goodness nobody was shot a couple weeks ago when people were out there with their guns and the protesters. All right, I'm going to look and see what other information and questions that we've been getting. Someone asked, what other kinds of cases are there that we handle other than car accidents? Because I know I talk about those a lot. We have the slip and falls that you've all heard of. But in addition to that, there can be other premises liabilities cases too, where it's not just someone tripping and falling on something. But we had a case against Walmart, actually, where they had made this big display tower that was unstable and fell and broke our client's nose. And we were actually able to get him settlement on that kind of case too. And then dog bites. Speaking of homeowners insurance pretty much always covers dog bite cases. So, even if it's your sister's dog that bites you and you worry, like, should I sue my sister? It's really just their homeowner's policy and they'll cover it. And, some of those injuries can be pretty serious. We also are doing wage and hour class action cases. The Missouri DOC case that comes up a lot was about failure to pay for pre and post shift activity that the officers were doing. They'd have to do a whole lot of work before clocking in and a lot of work after clocking out. And we're pursuing those cases in other industries as well, such as nurses. And so There's class action, wage and hour, overtime, not getting paid for things, for work before and after clocking in. Those are cases we handle, and we have a few of those lawsuits going right now. Medical malpractice cases, they are tough, but we do handle them. The thing is, for every malpractice case, we have to get a medical expert, and they usually cost thousands of dollars. So the damages need to be significant enough where we can actually put money in our pocket. So most malpractice cases that we take, people are, you have to be permanently injured under the law, or unfortunately, they've passed away due to negligence. But we have those cases. There's negligent supervision, where if you entrust your child in a daycare or your elderly mother in a nursing home and something happens due to negligence, we pursue those cases. We have product liability cases too, where, anytime you see a warning and it may seem kind of strange, like, I don't know, don't put your cat in the microwave. Well, that warning is probably on there because someone actually did that and got sued. So we do product cases too as well. Let's see if we have anything else that people are interested in. And also there's a link to our practice areas on our website too that goes into more detail. Someone asked about the statute of limitations to file a car accident lawsuit. So in Missouri, correct, it is 5 years. In Illinois, you only have 2 years, and that's 2 years from the time the accident happened. So that's not a whole lot of time. You want to make sure that you get a lawyer if you want to pursue it and get it on file before then. Basically, the statute of limitations says if you don't do something after this point, it's too late. And that's for every type of claim. It just varies by the type of claim. Let's see what else we have here. Along those lines, someone asked if all the injury lawsuits have the same statute of limitations. Most injury cases do, as far as car accident in Missouri, 5 years. Slip and fall, Missouri, 5 years. Medical malpractice, only 2 years. Wrongful death, only 3 years. So, and then if you're a minor and under 18, then you have additional time after you turn 18 to file the claim. So it really does vary depending on the case, but it's better to be safe than sorry. We make sure all that stuff is calendared, deadline. Don't want to mess up someone's right to recovery there. Going a long time, but there's one more question here. Someone said they were bit by a dog at a boarding facility. A third-party negligence case against the owners could be covered by their homeowner's insurance, or is it only if it happens on their property? Well, that's kind of tough, but the main case would be against the third party. They're the one who committed the negligence. They're the one who had the dog and let it loose. It's worth a try. It might be covered. You might be able to have a claim against the third party and against the person whose dog was on their property. But really, if you don't have your dog and you give it to somebody else, it's not really your responsibility at that time. So, all right, this has been a quick 45 minutes, maybe long for other people as I ramble on here, but thanks for putting up with me this week. I hope everybody had a safe 4th of July last weekend and is staying healthy and safe with everything that's going on. You know, we're still working hard here at Burger Law on all your cases. And if you have any questions, always feel free to give us a call, shoot us an email, comment on our Facebook page, and we'll try to get back to you any chance we can. All right, thanks. And I'm hopefully logging off now.